come to you, generally with some sort of claim being made by the defendant already, which is not unusual as we discussed, because likely they are sitting behind bars for a very long period of time, which lends itself to saying, I want a new attorney, which they're able to get if they raise an ineffective assistance of counsel claim, and I want to raise this because there's always something to complain about. It will be the job of the attorney reviewing the transcript to determine if there actually are ineffective assistance of counsel claims, whether it be based on what the defendant client has said or based on the review of the record. So it's not an automatic claim. It just comes to us with a claim, and you have to evaluate that. Even if the claim of the client is you deem it to be meritless, you still have to review the transcript for whatever issues are there.
All right, and not to prolong this greatly, but is it not the case that we too could become the target of an ineffective assistance of counsel claim down the road in a habeas case? If
Yeah, I've got one next week.
If we failed to raise the
The argument was I didn't raise on appeal that the trial lawyer was ineffective. Do you guys have an idea what a habeas case is? Okay. Hey, let me give kind of a general overview. Well, I don't do habeas work, never have. But it's a post-conviction process that's basically civil, where the defendant alleges he was basically convicted and sentenced, and that there were certain constitutional violations that led to that. He's not entitled to a lawyer during that process. So you get a lot of handwritten petitions and things like that. And the hearings are usually held in the counties where the defendant is being detained. So for me, for example, next week I've got to drive up to Cray, Georgia, and then a couple weeks later down to Morgan, Georgia, which is down near Tiff, because that's where the defendant is being held. But some of the other folks here with more experience, they've done habeas work, and I haven't. That's just a real general overview. Do you guys want to add anything to what I just said? Okay. Gerard?
There was some sympathy expressed for the poor criminal defense lawyers. And if I could just sort of view the other side of that, a lot of what I do is raising ineffectiveness against lawyers, and a lot of it's for the waiver issues that someone alluded to that in civil cases are just lost. But there's a benefit to that also, because it's sort of a teaching experience, and it not only teaches the lawyer, but sometimes I'll sort of pick up on things that the front lines just aren't getting, and I'm sort of a resource for the office the way Jim's a resource for the state. And there may be an issue that people just don't get, and then I'll send out an email to the whole office, like, how to preserve a motion for a mistrial. It's arcane and technical and crazy, and I bet 90% of the lawyers in my office don't understand it, even after I explain it to them. I mean, so yes, you can view it as attacking lawyers, but you're also helping that lawyer understand, and most lawyers want to try to be better. You try to object to this, but you did it wrong. But a fair number of lawyers will be like, oh, I didn't realize that. Well, now I know. Next time I'll do it better. So,
Right.
There is an upside to this continual attack and this education.
Okay. Any other questions or comments?
I meant to add one thing. When I listed resources, this probably is not something you'll do, but if you really decide this is an area that you enjoy, Henry County State Court Judge Ben Studdard, one of the really sharpest judges we have in our state, has his own product. It's called the Georgia Criminal Case Law Update. And you subscribe on an annual basis, and it provides not real-time, but very close to real-time summaries of important decisions in criminal context, broken out by decision area. And it's just a really worthwhile resource if ever this is something that you're interested in.
How do you subscribe?
I call up Judge Studdard. If you Google on Georgia Case Law Update, Georgia Criminal Case Law Update, I'm sure it'll get you to the link where it says if you want to subscribe to this 7-day free trial and all that kind of stuff. But it's a nice product that he's put together. And if you've ever had the pleasure to appear in front of him, when he rules against you, it's one of the most, you go, okay, I understand that.
Yes, sir.
I had a follow-up question to a question she asked earlier when we were talking about the second order from denial of a motion for new trial,
Okay.
and whether or not there needed to be a fact, that the judge needed to specify what the facts were, and it sounded like that they're not going to do it. The question is whether or not that raises an issue that there may be a waiver later if you're arguing about what the facts were that was determined at that hearing by not either, I think there's a method to request the judge expand on the order for the facts, and whether or not that becomes an issue in the criminal process or not.
There's none. I mean, you're up against the any evidence rule as an appellant, which means any inferences that can be drawn from the evidence against you will be drawn from the evidence against you. Moreover, I can tell you from my dabbles in habeas work where that kind of thing does happen, that as the representative of the defendant, you don't want aggressive fact-finding to occur. Because if it does occur, it will against you, it will be drafted by the prosecutor. And the prosecutor will frequently or always take some pretty broad liberties.
I'd say that in ruling on motions for new trials in my circuit, the vast majority of the orders that are entered are, having read and considered the defendant's motion for new trial, it is denied. Sir?
I know that you have to raise ineffective assistance of counsel in a motion for new trial, or if you don't, then it's waived for any future proceedings. But is that true of any other issue? In other words, can you choose not to raise some issues in the motion for new trial and just raise them for the first time in the appellate court?
Yes.
I think ineffective assistance has to be raised at the earliest practicable moment, I think is the language. But let's say you do this amended motion for new trial that I've been talking about. You are not confined to those issues up on appeal, necessarily. But I think that presupposes that the issue was already preserved, maybe during trial or in the trial process.
Yeah, functionally, exactly so. I mean, the new trial motion is a window where you are before a judge who has the power to hear evidence. So to the extent that you need to introduce some evidence to make an issue, to make an argument, the motion for new trial is your opportunity, and the subsequent opportunities are even less accommodating with habeas and so forth. But the general rule is, you are not bound by the issues you raised at the new trial stage. As a practical matter, I mean, unless something occurs to you later, I don't know why one would hold anything back. I mean, from my perspective, it gives me an opportunity to do a better job with the appellate brief and to smoke out the arguments that the other side might have and then be able to address them at the first shot at the appellate stage.
Yes, sir.
We haven't talked about a response from the state on the motions for new trial. What?
There's a reason we don't talk.
Yeah, I figured.
This is going to sound like a broad characterization. As I was saying earlier, the judge I work for talked about how criminal lawyers do a lot of good writing. Well, the state does almost none. I don't remember. I can think off the top of my head one time when I got a written brief in response to an amended motion for new trial from a prosecutor. They come to court, and they just say, I swear, in the first case I won in the Supreme Court, I challenged the constitutionality of that fucking conversion statute as creating a presumption of guilt. It's called mandatory presumption. We were going to hear the motion before the bench trial. I just wanted to preserve it for appellate review. The prosecutor was sitting there with some of the other DAs, and he stood up and said, I got to go in the other courtroom for a minute. If she comes out and calls for that motion, just say, He was floored when they reversed that decision unanimously. But I never get a written brief from the DA unless we go to the Court of Appeals and Supreme Court. And even then, a lot of times, you talk about format and font usage and things like that. The ones I've gotten have not been all that impressive. And they get the DAs I deal with get resentful when you file appellate briefs because they've got to sit down and write and respond to it. So, if you like writing, and most folks who are in civil firms have to do a lot of writing, this is another good way to add something, because DAs write as little as possible and get grumpy about it when they have to.
That said, if you have a case coming out of DeKalb, for example, they've got some pretty strong writers in their appellate. They've got some experienced writers anyway. I don't know if Lee is considered strong, but she knows what she's doing. I think she's pretty strong.
And my co-author, Randy Shepard, of the Augusta DA's office, co-authored the book, is a very able writer as well.
But at trial level, to some extent, the appeals level, you know, it's sort of, they put their resources where they got to worry. There's a reason you call it in a criminal context, not the Court of Appeals, but the Court of Affirmance. They know that, you know, the overwhelming number of times, they're going to win if they just show up.
And you know, they've got to be careful too. One of our assistants in my circuit, I guess her trial schedule was you know, kind of hectic. So she submitted her response brief in the Court of Appeals case that we had together like 6 months late. And when the Court of Appeals overturned the guy's conviction for insufficient evidence, there's a big footnote in that opinion, naming her by name, saying that the brief submitted by the state, such as it is 3 pages long, was filed 6 months late, it is devoid of any reasoned legal argument. So, you know, and there's that kind, and I don't think it really affected her. I don't think she cared. Now, I care, and I know you do, but, you know, there's, at least in my circuit, there's a cavalier attitude about doing writing and responding to appellate briefs. So, if you do good writing and put together a quality brief, you know, you are making an important contribution to this process. Yes, sir.
Can a judge deny a skeletal motion for new trial without a hearing?
No, not if you ask for it.
Okay, and when do you ask for an evidentiary hearing as opposed to just arguing?
I think that depends on what issue you're going to raise, and you've got to make that determination. If it's, for example, you know, the trial court erred and given this instruction that they shouldn't have given, you might could just do that with you, the DA, and the defendant arguing in front of the court. But like ineffective, for example, that kind of changes how you handle that motion for your trial hearing. So it kind of depends on you, how you want to approach it, but also what the issue is. Jiminy?
I just wanted to add one thing as far as the timing. When you get the case as an attorney that's appointed on it, you'll have the responsibility to notify the client and the court of your appearance on the case. At that time, that's when you want to reach out to the court and to the DA because, you know, it may start a scheduling track for you on that case. So you would want to be able to tell the court before then, I'm going to file an amended motion for new trial, and in that you could request the evidentiary hearing. But that's when you first come on the case. You want to let everybody know, I'm the new attorney on the case, so you get information. So you won't end up, and they say, well, we're going to put a hearing on the calendar, schedule a hearing on this case, and then you find out a couple of weeks before, and you're not prepared. So you have to be proactive once you get appointed to the case.
So as a practical matter, is that when we'll get the case, someone will have already filed a skeletal motion for a new trial, and the case is just sitting there, and then those cases will be presented to our law firms, and we'll volunteer for some cases, and then we have to enter a notice of appearance and start working on the amended motion for a new trial? Is that?
I would think so, but I want to get the guys from the actual appellate division to answer that if you could.
All of the cases that we receive at this point, they have a motion for a new trial that's been found in them, and that's the skeletal motion. So you'll be getting the case after that point. We may not have all the documents in our office, so we can't tell you everything that's been done, but you'll have access to the trial counsel and to the administrator at the Circuit Public Defender's Office who will have the information as to the exact status of the case, and then you will go from there. Now, what happens when the case, how the case moves once it's at your firm, I'm not sure of that.
So, well, what lawyer will have filed the skeletal motion for a new trial?
It will be the trial counsel, and in some instances, it will be the Circuit Public Defender, but generally it's the trial counsel. They do it pro forma.
So we'd have to be substitute counsel for them because they can't stay in the case, otherwise you couldn't raise ineffective assistance of counsel.
Correct.
Any other questions?
I just want to make sure I'm saying that when the cases come to our office, the appellate division handles the conflict appeals. So at that point, it's been conflicted out of that Circuit Public Defender's office. So when it comes to us, at that point, almost everyone knows, the court and everyone else knows, that there's going to be a new attorney appointed to the case.
Okay. I'll be around the rest of the morning, well, the rest of the day, actually. So if you have questions that come to you while I'm here, you're welcome to stop me and pull me aside. And I think the schedule is that we take a break now from 11:15 to 11:30, and then come back at that point.
If I can say one thing, I know you're going to run up and run to the restroom, but I want to point out in the packets that you have, we were talking about forms today. There is a CD that has a copy of the appellate manual that's been put together by Jim Bonner, and also a copy of an appellate manual that's been put together by Robert Purse. Those are valuable materials for you to take a look at. You'll see forms, you'll see timelines, you'll see narrative that will explain different things in the appellate process that will supplement what you hear today. It's a process of learning. And we know by the show of hands earlier that most of you have not done criminal appeals, but that will help you greatly. So please take a look at that in addition to the printout material that you have in that packet. And we'll see you back in your seats at 11:30.
Yeah, let me just add this quickly. The outline that's mine on the CD is what happens if you're the trial counsel and you lose and you have to handle the appeal as well. And I was telling Tricia earlier, I'm going to supplement the materials at some point, at least at the central office, with what happens when somebody else has tried the case, and then you're basically handing the file as the appellate counsel and include the points that I was talking about.
Which is going to be tricks of the trade, spotting and choosing appellate issues. We talked a lot this morning about the mechanics of how you move a case along, where that case is going to end up at the Superior Court, at the Court of Appeals, at the Supreme Court. And we'll touch a little bit on ineffective assistance issues, which we'll deal more in depth later on. But what we're going to move into now is what you actually do once you get that transcript, once you get the record of the case and you start looking through it. How do you identify the issues that are going to be viable at the motion for new trial and on appeal? To help us do that, we have another panel of esteemed colleagues that includes Chris McFadden, whom you heard earlier, as well as Jim Bonner as facilitator. And you've already heard a lot about him. In addition, we have Cindy Wong, who works with me in the appellate division. You have her bio in the handout that you've been given, and also Mr. Steve Phillips. They all bring a differing yet and unique perspective to how to spot and choose appellate issues, how to vet those issues, and then how to elaborate on them so that you can get the most bang for your buck when you're arguing to the court. So with no further ado, I present to you tricks of the trade, spotting and choosing appellate issues.
Hello. I'm going to start because my role here today is basically to be a cheerleader for you guys. Not too long ago, I was in your position. My legal career predominantly, prior to being transferred over to the appellate division, was civil, and I did most of the policy work. So criminal appellate practice was completely new to me when I transferred over to the appellate division. As you can see from my bio, I'm the senior staff attorney because I'm the only full-time staff attorney under Ms. Rogers. And of course, we fortunately have Jim Bonner with us still because I can't do my job without Jim. I mean, he's just phenomenal. Anyway, so I told Steve and Jim today that I'm just going to be the Rob Schneider character in Waterboy. You can do it. I mean, you can. I know it's a daunting task to look at, especially a multi-volume trial transcript, to come up with issues. And you're going to come to that point where after you read that transcript, you're going to be like, I didn't see anything. Did I miss something? And a lot of times you are going to have trials that were just cleanly tried. And there's not going to be that many issues, and so what do you do? Jim and Steve and Chris are going to talk about that too, the substantive portions. They'll mention that, I mean, obviously in Georgia we can't file Anders brief, so we have to come up with something. And a lot of times, we'll raise insufficiency of evidence. And the way I kind of approach it when I'm trying to come up with the issues is when I'm writing the brief, if if I can't seem to make my fingers type it, and that's not a good issue. Jim has the laugh out loud test. If you actually can write it without laughing out loud, you can write it. But yeah, but you really can come up with issues. There is always insufficiency of evidence. And you look at all the court errors, and Steve's going to talk about digesting a case. I don't think that was really covered during the first part. But when you're digesting cases, when you're first spotting the issues and really going through that, I wanted to just give a couple of practice pointers. Tom had mentioned this earlier too about reading the new cases because you get ideas for issues. A lot of times you may want to raise venue charge has been given, or if there was an edge problem, whatever. But if you look at the cases, you kind of get an idea of what type of issues to look for. Tom also mentioned what's the decision that is put out by GACL that always has it sets it up with based on the issues of how the Supreme Court and the Court of Appeals rule. And sometimes you have some federal cases in there too. I wanted to mention, I know Gerard takes copious notes when he reads the trial transcript. In my case, I take a lot of notes when I'm digesting a trial transcript, but there are portions of the trial transcript that I want to go back and review more than once. Practically, I like to review the whole trial transcript over again, but a lot of times you're constrained by time. So there's particular portions that you really need to pay close attention to, and that includes like jury instructions, because chances are you're going to a lot of times find your issue in the jury instructions. And Robert mentioned this in the first session, that you want to check the records to make sure that those jury instructions are in the record. If the defense requested it, and if there was a problem with it, then you're going to have to raise an effective assistance of counsel. So you want to make sure that all that is in the records. A lot of times, like I mentioned before, I can't do my job without Jim. And in my 2 years that I've been with the division, I've had some appellate successes. Due to in large part to Jim Bono and Jiminique Rogers. When you're kind of new at doing this, you rely a lot on the people with a lot of appellate experience. And so, please feel free to call upon us. If you have a question, or if you particularly want to vet an issue, we often have these case discussions where we talk about a case, and we'll go, okay, well, what do you think about this particular issue? Is that something that I need to spend more time on, or things of that nature? So, with that being said, I'll turn to these learned professionals in our seat.
I'm going to talk about pretty much what I do when I get a case and how I start out thinking about it and trying to go through it. I'm sitting at my desk. I've generally got a transcript that could be anywhere from 500 to 4,000 pages in front of me. I've amassed as much as I can from trial counsel. If I can get his trial file, that's great. I've had cases where, I have a case that I'm working on now where trial counsel's trial file was destroyed in a flood of his office, so we don't have that. I'll get the trial file, I'll get the discovery from the clerk's office. So I'll have police reports, witness statements. If you're getting cases from Fulton County and it's a large case, now they've started doing pretrial witness interviews where they'll develop, they'll have a big interview of the witnesses that they're using, and they'll have transcripts of these witness interviews. So I may have extra transcripts of witness interviews as well. And I've got all this material in front of me, and what I'm trying to do with it is I'm trying to get a sense of how strong this case was for the state. And the reason I want to do that is because finding a mistake or an error in the transcript is not going to be enough to make a good issue. There's two parts to every issue, to every winning argument. And that is finding an error and and also finding an error that's harmful, that is, it had some sort of effect on the outcome of the trial. And depending on what the category of error is, you're going to have different standards for assessing the harm in the context of the trial. So I really want to try and get a feel for, is this a case where it was a closed case? Was this a case that relied on one key witness for the state? Was this a case where my client shot somebody in a public place and there are 14 witnesses who've known him since he was 5 and they're all identifying him? Okay, because that's going to, depending on how strong the case is for the state, that's going to sort of start my thinking about what kind of issues are likely to work in this case. And so, again, talking to trial counsel, talking to the client, going over the discovery are good preliminary steps to sort of get a little grounding about what this case is about and, how strong it's looking for the state before you even start diving into the transcript. You have a sense of where it's going. Once I've done that, I'm going to get the transcript and crack it open and start reading. And, there may be pretrial motions that are always good sources for issues. Any adverse ruling can be appealed. It's going to be jury selection, which is, again, another good source for potential issues. And then there's the body of the trial itself, where you have the evidence, the opening and closing statements, the jury charges. And when I'm reading a transcript, and I think they may have touched upon this in the first segment this morning, but one of the most important things that I do is I do what's called digesting the transcript. That is basically detailed note-taking of what I'm reading, where I indicate page numbers. When something happens that seems significant, I'll take copious notes on that particular issue. And if there are issues that I spot, for example, there's a hearing about, pretrial about whether similar transactions are coming into evidence, and I'll note where that happened. And I've had my own method of highlighting it so I can see this is a potential issue. And I'm not deciding at this point whether it's going to be an issue. I'm just trying to be over-inclusive from the start. That is, anything that smells like an issue, that looks like a potential issue, I'm going to flag it and then develop what will be later like a master list of potential issues, and then I'll start whittling it down from there. I had a note about, don't dismiss your client as a source of potential issues. Sometimes things happen that are not reflected in the record. Your client was at the trial. You weren't. And so your client or your client's family can be important sources of information. Now, granted, sometimes there's a lot of sifting that has to go on because your client may want to talk about a lot of things that he perceives to have been unfair, that really have no relationship at all to any sort of issue that's ever going to have a chance of prevailing on appeal. But in those initial phases when you're talking about the case, the best thing you can do is just to listen. Because if you sift through all the extraneous stuff, every now and then a nugget's going to come out. And if you dismiss your client from the get-go and you're not listening to him because it's not making a lot of sense, you may miss that nugget and you may miss your chance at something that's going to reverse the conviction. So from that point, digesting the transcript, taking notes, identifying issues, that's the initial stages of what I do. And like I said, I generate the master list of issues, and I'll work back from there.
And if I could add, Steve, basically the way I approach digest is that this digest is going to help me draft the brief. And so you want to basically make sure that it's concise enough that it's workable, but you don't want it to be with a lot of extraneous stuff in there that a trial transcript would contain. And so you just basically want to make it I'll make sure all the important facts are in there with the page references so you can easily. Okay, here we go. Okay, but basically, you just want to make sure that it has the page references, so then you can easily go back when you're writing your brief and say, okay, well, this is when witness A said this, that went towards the intent element. And you also want to go ahead and put in everything dealing with the objections that were made by the defense if the trial court overruled that objection. So you want to just go ahead and put it in there. And what I like to do too, I know Jim and Steve, if y'all agree, is I go ahead and put my little mental notes in there too, like, you know, if I felt like the defense should have objected at this particular question and they didn't, and, you know, if some harmful hearsay statements came in, you know, what defense counsel did to try to cure that. So I go ahead and do that, and you know, again, if there's any type of motion in limines or whatever, you want to include all of that in your digest. That way, and I'll go ahead and put in a list of potential issues that we'll have to afterwards go through and vet. This is something that I think Robert touched upon too at the morning session was, you know, he likes to keep a separate list of the possible issues. I go ahead and put it all in my digest, but I'll have it in one central location. And I go ahead and put in any pertinent case law too, so that way when I'm going back and working on it, I can look at the case and go, okay, well, this case said this particular thing, and so if I add it to my brief.
Let's see if Chris had anything. Chris, you want?
Yeah, but, a general observation about error selection, and then I'm going to talk about digesting too. I think that there are two successful narratives that recur in criminal appeals. One is that the truth-seeking process was so badly impaired by an error that we can't count on the reliability of the outcome. And the other potentially successful narrative is the procedure that was followed here represents a threat to and tends to undermine our fundamental rights in such a way that notwithstanding that the outcome is reliable, we can't allow this decision to stand. I think there may be some other appellate arguments that can succeed that don't fall into those categories, but at the moment I can't think of them. So in brief, in error selection and error winnowing, the ability to articulate those considerations is critical. And winnowing, I think, is critical, particularly in death cases. There are some reasons for putting some things in that you don't have a lot of faith in, perhaps. But that comes at a cost. What is said in civil cases about appeals is true in criminal cases as well. Good arguments are weakened by association with bad arguments. Strongest appellate briefs, I've heard an appellate judge say that, you know, a lawyer who will raise only one issue, as far as I'm concerned, is a king. One who will raise two is maybe a nobleman. 3, you're still a peasant, and 4 or more, you're a serf. I think that's critical. I think selectivity is critical. I think combining the issues into a clear narrative about the reliability of the truth-seeking process, about, you know, innocent people do get convicted. That's the major reason we do what we do, is important.
Let's see, I just had a few things to add chiefly to what Steve said about how you attack a transcript. Let me get one thing out of the way real quick. Every one of you who takes one of these cases is going to have a very anxious client. And one of the banes of appellate work is that a lot of it is off the horizon. Nobody sees, you couldn't do a TV program of somebody writing an appellate brief or doing appellate research, for example. Not one.
I saw a number of cases that became somewhat celebrated in the press, but always in the parts where I was not involved.
But anyway, you've got a very anxious client, and he obviously wants to help himself. He is tremendously ill-equipped ordinarily to help himself, because this is, once you're dealing in the appellate phase, you're really in kind of an academic area, and an esoteric area. But as Steve said, you shouldn't overlook that he is the one person who should have been there throughout the whole proceedings, and he may know something. The problem is, when you get the case, you're not going to be able to fit what he knows or what he can tell you in the context until you've gotten up to speed by reading what's available on the printed record. One of the things that I do frequently with some success is to contact the client and say, look, I'm not going to understand anything that you're going to tell me until I have gotten up to speed. I'm going to have to read all of this. But at some point, I will know everything that's in the record, everything that's in the transcript. And you don't need to tell me about that. What you need to tell me about, if you want to help yourself, is to tell me what I might need to know about this case that you think is important that I wouldn't pick up from the record and from the transcript. Well, he may actually have something. Even if he doesn't, he's going to be gainfully employed kind of helping himself, and that's going to take the pressure off of you. And you tell him, look, when I get your letter, I'll lay it aside. When I've read the transcript, then I'll be able to fit in the context of what you told me, and I might have some questions. I'm probably not going to have any questions more for you, until I got to that point. Anyway, as I said, it's very beneficial because it gives him a feeling of participating in his own appeal and of helping himself, because believe me, he's spending 24 hours a day not doing anything productive. The other thing that I want to point out is sort of part of the preparatory work to attacking the record of the conviction is to look at the indictment, to read the indictment, to outline the indictment. It's a little bit surprising to me how seldom trial lawyers even do this. We'll probably get into this later, but there are a great number of issues that really come out of the indictment when you interface it with the trial particularly. Unless you've really taken a careful look at that, you wouldn't, this whole area of legal error would be obscure to you. The other thing is to take a look at the statute defining the offense, or the statute's relevant to any other issue that you know is in the case. But from the indictment, from the charges, that the statute defining the offense is going to be an important thing. And you need to read the record both with a mind to what the indictment has said, what it's identified as the elements and the issues, and what the statute has said. And a lot of times there can be interesting questions if you apply some thought to that about what these things mean, what proof is amenable, can come in under any of it. The other thing is that you may have a case with a mixed verdict, a multi-count case with several acquittals, or